Elizabeth Kirk. I teach some of you here at the law school, and I also direct the law school's new Center for Law and the Human Person. The mission of our law school is to achieve distinction in the Catholic intellectual tradition and to promote certain ideals, among which are the dignity of the human person, respect for the inviolability of all human life, justice rooted in the common good, care for the poor, the neglected, and the vulnerable, and the obligation of love for one another. So the goal of the Center for the Law and the Human Person is to be a resource for the law school for thinking more intentionally about how these commitments ought to inform the study and the teaching and the practice of law. So we're going to do that by supporting faculty and students, and also by sponsoring events like the series today. So we're grateful, I want to say, to the Institute for Human Ecology for their co-sponsorship of this lecture series, and in particular to the support of their master's program in human rights, which is directed by Bill Saunders, who's here with us today, and especially for spreading the word to the rest of campus. If you are interested in learning more about the center's work and our activities, especially as we get underway in the coming year, there is a sign-up sheet, and so I encourage you to put your name and email address on that. So today's lecture is the second in a series exploring different angles that are related to the Dobbs v. Jackson Women's Health Organization cases pending before the Supreme Court right now. So for those among us that maybe haven't attended law school or haven't yet attended law school, you're welcome to check us out while you're here. Or who were unable to attend the first lecture where our law school professor, Joelle Alicea, lectured on the constitutional implications of this case, I'm just going to give you a little background about the case. So Dobbs involves the constitutionality of the Mississippi Gestational Act, which forbids abortions after 15 weeks gestational age. And the question before the court is whether all pre-viability prohibitions on elective abortions are unconstitutional. That question and the possibility that the court might uphold the Mississippi statute directly implicates both the central holding of Roe, which is that there is a constitutional right to abortion, and the viability rule of Casey, which states that states may not prohibit abortion or even place an undue burden on a woman's right to access abortion before viability, which is widely viewed to be somewhere around 22 to 24 weeks. So a 15-week ban, of course, directly implicates that. So what the court might decide, the reasoning it might employ, the possible variations on how it might rule, et cetera, is the fodder for what this series is meant to discuss. And so we've had a lecture on the constitutional interpretation questions. We'll have Professor Crawford's lecture today. And then finally, on April 5th, we'll welcome Helen Alvarez, who's a professor at George Mason, to give the final lecture in the series, which will contend with the argument, the social equality and reliance argument, that women's flourishing depends upon the availability of abortion. So today we are grateful to have Professor David Crawford address the philosophical and anthropological implications of the Viability Standard. Dr. Crawford is Dean and Associate Professor of Moral Theology and Family Law. In other words, he is a lawyer and a theologian. So he received his law degree from the University of Michigan, which I don't think I knew about you. And as a Notre Dame person, I'm bound to, you're my sworn enemy now. I didn't realize that. But his law degree from Michigan and his STL and S.T.D. from the institution at which he now teaches, the Pontifical John Paul II Institute, which is located right here on our campus. Dr. Crawford teaches and writes at the JP2 Institute in the areas of fundamental moral theology, bio and sexual ethics, marriage and family, and law. So please join me in welcoming Dr. David Crawford. If you want.
So I've been told I can take this off, and I'm probably as immune as anyone in the universe at this point. So hopefully no one's in danger. Michigan and Notre Dame, one consolation is I never in all my time there went to a single football game. So that might help. Okay, so we're talking about Dobbs versus Jackson Women's Health. This case is presently before the Supreme Court. And, I'm to talk about viability. And I think, the case really turns on this question of viability. What is viability? What is the basis for viability? Although Justice Barrett stated in the oral argument that the case turns on stare decisis, but this would only be true on the supposition that Roe and Casey, and the many cases that follow from them, were wrongly or at least questionably decided. So it seems to me her statement presupposes something already about the sort of substance of the case, you might say. Setting that aside, then Dobbs really does turn on the substantive question of viability and its basis. And as Professor Kirk had stated, the Mississippi law in question would ban elective abortions after 15 weeks, well before the time of viability at 22, 24 weeks. So what is the viability standard? I just wanted to very briefly talk about viability for any, not all of you are law students, and some of you may be in my class at the Institute right now, and we haven't gotten to abortion yet, so I'll just briefly go over this. Roe versus Wade employed the concept of viability, the point in pregnancy when the fetus can, with a great deal of medical intervention, in principle survive outside the womb. But in Roe, the concept of viability was used as a support for the famous or perhaps infamous trimester framework, according to which pregnancy is divided into 3 parts. And in the first part, the first few months, according to Roe, the state is not really empowered to offer any regulation of abortion at all. During the second trimester, the middle period, the state is allowed to legislate on behalf of the health, the life or health of the mother. And then finally, in the third trimester, which is about 27 weeks, so actually after viability, but close. The state's interest in what Roe called potential life rises to the level, Roe said, of compelling. And therefore, it's the interest of the state could defeat Roe's application of strict scrutiny to the legislation concerning abortion, which the court deemed to be abortion, which the courts deemed to be included as a fundamental right under the rubric of privacy. The key here is that during the first trimester, according to Roe, the state could regulate on behalf of potential life of the fetus, up to and including by means of the prohibition of elective abortions, so long as there were exemptions for life and health of the mother, which were broadly interpreted under the companion case, Doe v. Bolton. It's important to remember, because I find people always get confused about this. Viability, again, 22 to 24 weeks, is not the point at which the legal recognition of personhood applies. Rather, it's only the time at which the state may begin to regulate abortion for the protection of potential life, in the words of Roe. Viability, therefore, signals a kind of shadow existence for the sake of possible legal recognition. The fetus is not yet treated as fully human, but it is close enough to warrant the possible but not necessary concern of state legislators. Personhood in the full legal sense occurs only at live birth. At live birth, on the other hand, not only can the state legislate to protect life, presumably it also must do so. Casey in 1992 claimed to uphold Roe's basic right to abortion, as Professor Kirk was just saying, but it modified Roe to eliminate the trimester framework, which was said to be unwieldy and sort of overly legislative, which, to paraphrase Chief Justice Roberts in Dobbs the Dobbs oral argument, left the court only with the viability standard. Since Casey states are said to have an interest in unborn life throughout pregnancy. However, they may only regulate abortion prior to viability if the regulation does not pose an undue burden on the right to abortion. After viability, the state may ban abortion or elective abortions so long as there are exceptions for the life and health of the mother, as under Roe. So Mississippi's abortion ban of elective abortions after 15 weeks with life and health exceptions directly challenges Casey, as Professor Kurtz said, since it seeks to ban abortions prior to viability. Because of the concept's importance, several of the justices in oral argument in Dobbs pushed hard on the two attorneys defending Casey's viability standard. The attorney for Jackson Women's Health, Julie Rickleman, and the U.S. Solicitor General Elizabeth Prelogar. Chief Justice Roberts and Justices Alito and Barrett each focused on the standard's seeming arbitrariness. Indeed, Roberts explicitly cited Justice Blackmun's own statement that the viability standard is arbitrary, or was arbitrary. For her part, Barrett observed that the line could be drawn later than viability in pregnancy, as had in fact been the case with Roe's trimester framework. Hence, she asked, why couldn't the line be moved earlier, as Mississippi is trying to do? In other words, both Roberts and Barrett were asking if there is any clear and principled basis for upholding the viability standard. In response, the attorneys argued that the viability standard signals the point at which the fetus can potentially live outside the womb. It therefore also signals a kind of independence, as Prelogar argued, separateness from the mother. Here, Roberts responded, referring to John Hart Eli's famous criticism that this amounts tautologically only to a definition and not a principle. The two attorneys also insisted that the viability standard is principled because it is reasonable. It balances women's and states' interests, it was argued. On the one hand, it gives the mother enough time to decide to have an abortion if she chooses. On the other, it allows the state to exercise its interest as the potential life of the fetus becomes more developed. To move the standard to 15 weeks, as Mississippi seeks to do, is to throw off this balance, according to Rickleman and Prelogar. Moreover, it invites states to challenge the court with a slippery slope. If 15 weeks, then why not 12 weeks, or 10 weeks, or 6 weeks? These considerations spawned what I thought was an especially interesting line of inquiry on the part of Justice Alito. To say that the viability standard balances interests may state a motive for using the viability standard, but it comes no closer to stating a principle for seeking that moment for selecting that moment in pregnancy than the merely definitional explanation had. To say that it strikes the right balance fails to provide a principle for saying why it is the right balance, or why the court should be balancing at all when it comes to such weighty matters. Alito pointed out that the mother's interest in getting an abortion is the same immediately after viability as it was before, and that the interest of the fetus in having a life is the same before as after viability. So nothing seems to change in this regard at viability. Hence, striking a balance at viability seems arbitrary, Alito argued, as compared to Roe's 27 weeks or Mississippi's legislation at 15 weeks. It is in this context that we find a really fascinating line of questioning, one that gives us a clue as to the kind of principle Alito seems to be seeking. The viability standard, Alito complains, seems to depend more on medical technology than on the fetus itself. As he observes, medical technology has changed and might change further. So viability is a moving target and one that turns on developments extrinsic to the fetus. It does not seem very satisfactory to think that the status of the fetus and the state's interest in protecting the life of the fetus could ride on the changing and variable conditions of medicine and medical technology. Here then is the basic problem with viability Alito suggests. If such a consequential line is to be drawn regarding how we are to understand and treat the fetus, shouldn't that line be based on something intrinsic to the fetus itself? Wouldn't an adequate principle rest not on such external factors as medical capabilities, but on something inherent in the fetus? Shouldn't the criterion for a changed legal status depend on some bright line in the fetus's actual development? What change in the fetus itself can be pointed to that would justify the highly consequential division for purposes of law between pre and post viability? Hence, at one point, Alito asks, given the competing interests of the mother and the fetus, is there some point in which the independence or separateness spoken of by Rickelman and Preliger might occur, but intrinsic in the dynamics and development of the fetus itself? By asking whether a principle for viability can be found in relation to the fetus itself, Alito seems to seek some anchor, some reality outside of law, and indeed outside the mere mediation or balancing of interests or the circularity of purely positivistic legal definition. He had earlier asked the Solicitor General of Mississippi if there are any secular philosophers who think that human life in the proper sense begins earlier than viability, say at conception. Alito was trying to counter Justice Sotomayor's argument that setting any sort of beginning to life, it must be purely theological. Nevertheless, his question betrays the kind of principle he's looking for. He seems to be looking for a philosophical principle. In order to give a proper context to this question and its significance, we should look a little of the earlier case law. So I'm going to begin with a case that I've used for years, but it's not very well known. But it's from 1972, just before Roe versus Wade, from New York. So it's a New York state law from the New York Court of Appeals. So this is decided just before Roe. And what's interesting is it's almost the mirror opposite, if you will, the mirror reflection of Roe. In this case, you had a very permissive New York legislation, and you had someone suing on behalf of fetuses to overturn the law. And so you see it's postured exactly in the opposite way from Roe, from Casey, and from Dobbs. The court held that the suit failed because the question of personhood is purely a question of law rather than nature. So an argument was made that the fetus is by nature a person, and therefore when the law talks about person, it must also be talking about fetuses. So the court is saying that whether the unborn are persons under New York law is a question of pure positive law and therefore lacking necessary roots in nature. Just because a fetus might be a person from the natural point of view really has no bearing on whether the fetus is a person in legal terms. Indeed, the court said that the question of legal personhood is purely definitional. This is what I mean by that circularity of definition. What is a legal person? This is a quotation from the case. What is a legal person is for the law, including, of course, the Constitution, to say, which simply means that upon according legal personality to a thing, the law affords it the rights and privileges of a legal person. The process is indeed circular because it is definitional. The court argues that just as a corporation's status in law as a person does not make it a person in nature, so too the fetus's possible status in nature as a person has no bearing on whether it is to be considered a person in law. So notice there's a little bit of a non sequitur here, right? In the sense that the corporate personhood is a legal fiction. Just because it cannot be read back into nature does not mean that nature ought not to be the foundation for law, or that the use of the word person in law ought not to be rooted in the reality of natural person. In fact, I would even say that the fact that it's possible to have this fiction relies on the reality of natural personhood, right? The existence of real persons. That's an aside. More importantly, however, the court's ruling effectively severs the idea of personhood from anything outside law itself. Law seems in this instance to be completely separate from natural things such as fetuses. A scathing dissent points this out and suggests that it is a dangerous path to travel down, drawing parallels to historical situations in which the natural persons were considered legal non-persons or something less than legal persons. Notice, however, that this decision is conservative insofar as it exhibits judicial restraint. And in that sense, it is postured differently, as I said, from Roe, Casey, and Dobbs. Nevertheless, its significance for our topic today is that it precludes a sort of rational principle centered in the fetus itself that Alito seems to be searching for in his seeking a principle or foundation for the legal status of the fetus, and for whether or not viability is a principled line to draw. If there is no necessary foundation for law in nature, then a legislature could draw the line at 27 weeks, 24 weeks, 15 weeks, or any other number. If the law granted personhood, which I grant is not at stake in Dobbs, it could do so in any way it chose. Now consider Roe. Roe addresses and dismisses two arguments offered by Texas in defense of its restrictive abortion law. Texas first argued that the unborn are persons under the 14th Amendment, and that on that basis, Texas had the authority and indeed the duty to protect them. Here, the court had two responses. First is a historical one, and that is that historically, fetuses have not been understood as persons in the full sense. Now, you know, the historical argument is complex and difficult, right, and controversial. And also, it's unclear the extent to which it ought to influence modern courts. What do you do with the fact of the earlier lack of knowledge concerning how conception works, for example, or what to make of the fact that there could be many ways in which the common law understood things differently and less well than we do now? Okay, but second, the court in Roe dismissed this argument under the 14th Amendment by pointing to other uses of person in the Constitution that cannot plausibly refer to the unborn. For example, when person is used in describing qualifications for public office. However, as John Hart Eli pointed out, the same could be said of children who clearly are persons under the 14th Amendment. On the basis of these arguments, the court concluded that the fetus is not a person under the 14th Amendment, i.e. is not a constitutional person, is not a person under the, as defined by the Constitution and the 14th Amendment. Needless to say, this judgment, like that in Byrne, is simply a matter of positive law, without any attempt to link the 14th Amendment's use of the word person to the question of what a fetus is, either in theology, philosophy, or science. Texas' second argument was that notwithstanding the question of the 14th Amendment personhood, Texas has an interest in human life and may or even must legislate to protect it. After all, the 14th Amendment is one of the Civil War amendments passed in 1868, and states have been prohibiting homicide, for example, for a long time before the Civil War. So the state's authority or power to pass laws protecting human life does not depend on the 14th Amendment. This is Texas' basic argument, I think, in the second argument. It is to the second argument that Roe responded famously by saying that Texas may not impose its own theory of when life begins on individual women. We need to study the nature of this second argument and the court's response more carefully. First, the court and Roe, and Roe's author, Justice Blackmun, clearly understood that fetuses are alive, right, when it talks about imposing the theory of life, of human life. Fetuses are alive. It knows, for example, that there's a difference between living and dead fetuses. Moreover, it knows that we are speaking of human fetuses and not some other sort of fetus. From this point of view, the fetus is clearly a human fetus and not only a potential life. So when Roe tells Texas that it cannot say when life begins, it is clearly not referring to anything empirically available. For example, it is not referring to our knowledge that this fetus is alive and that one is dead, or that this one is a human fetus and that one is a chimpanzee fetus. Rather, it is referring to the status of the fetus as something more than is quite available empirically. In effect, it is referring to the metaphysical or ontological sense of the fetus as possessing the dignity of personhood, even if not 14th Amendment personhood. Texas was arguing by alternative. If the First Amendment, if the first argument that the fetus is a person within the meaning of the 14th Amendment fails, then at least the fetus is a person by nature on the basis that the kind of life we are talking about is human life. In effect, then, when Roe rejects Texas' second argument for natural personhood, if I can put it that way, it's not the language of the court, but I think you have to deduce this. This is what's really being talked about. It is saying that Texas cannot impose its own understanding of when this personal nature begins. Like Byrne, but from the opposite point of view, the Roe court effectively severed law from nature here. So where you have Roe's, there you have Roe's response to Alito's question, right? Roe has already answered Alito's question, if I've understood his question correctly. The law simply cannot look to the thing in itself, namely what a fetus really is, which is inherently a philosophical question. However, this is not a sufficient answer. Roe's rationale for this response seems to be that because there has always been disagreement over when life begins in the pertinent sense among philosophers and religions in history, it is not for the Texas legislature to select one position and impose it. This sort of disagreement among groups would not in itself be enough to preclude a legislature from taking a position. For example, there is much historical disagreement surrounding slavery and racial discrimination or the role and status of women in society. This has not meant that legislatures or courts could not act decisively. So why can't Texas look to the question of what a fetus is? Why can't it address the metaphysical or philosophical question? For an answer to this, let's turn briefly to Planned Parenthood versus Casey, our third case. Consider Casey's famous passage concerning the mystery of life, or as Justice Scalia, I think, derisively referred to it, the sweet mystery of life passage. Our law affords constitutional protection to personal decisions relating to marriage, procreation, contraception, so this is a quotation, family relationships, child rearing, and education. These matters involving the most intimate and personal choices a person may make in a lifetime, choices central to personal dignity and autonomy, are central to the liberty protected by the 14th Amendment. At the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. Beliefs about these matters could not define the attributes of personhood were they formed under compulsion of the state. Like Roe's rejection of Texas' imposition of one theory of life, this passage tells us that government may not impose its view concerning what we could call absolutes, right? That's really what's at stake, absolutes, the big stuff, right? Such as when life begins, because to do so would limit individual autonomy and the ability of the individual to decide for him or herself on the meaning of things. In essence, Casey, like Roe, is saying that government may not look to the fetus itself because to do so is to make a philosophical judgment and this would replace the freedom of the individual to make his or her own judgments. Again, we have another example of the deracination of law from nature. And yet, despite these implications of Byrne, Roe, and Casey, perhaps the viability standard does imply a judgment about the nature of the fetus after all, but also of the nature of the mother and of humanity generally. Viability is claimed is a principled standard because, as we saw, in indicating the time when the fetus can survive outside the womb, it also stands for an incipient level of independence, an independence that only grows with birth. Hence, the beginning of sort of the shadow existence I talked about under the law. But what is not stated is why independence should be the criterion for the kind of shadow existence I described earlier, which is a basis for the respect law accords the viable fetus. Let me present two possible senses of independence. So, what do we mean by independence? In a certain sense, that becomes the question, doesn't it? First, independence might mean what I will call extrinsic independence. This sense of independence understands relationships as fundamentally voluntary on both sides. It supposes that I am free to enter into relationships with others, but I am also free to end my relationships. By implication, on the other hand, if my survival or continued existence depends on the cooperation or help of others, I fall short of this kind of independence. By implication, I also fall short of the paradigm of voluntary relationships. If my personal existence develops and increases based on this kind of independence, then the maturation of my independence and personhood implies ever greater separateness from others and ever more complete choice in relations. On the other hand, the implication goes in the other direction as well. If I'm in a state of dependence, I still have something less than full personal existence. But there can be a second sense of independence or separateness, which we will call intrinsic. This sense of independence or separateness could simply refer to the wholeness and trajectory of the personal human organism, the arc of life that is possessed by every individual member of the species. Here, the independence would simply point to the fact that the fetus or the embryo or zygote is a whole and not simply a part of another organism, such as the mother. In other words, it means possessing one's nature as an individual organism, an individual instance of a nature. But then we are talking about human nature. Is this not what we mean by person then? With its capacities for freedom, reason, and love? In this sense, independence of independence, dependency on the care and even essentially non-voluntary relations of the family do not stand as a limitation of independence or separateness, nor do they stand for a diminution of personal dignity. Nor does the fact that in reality, none of us is truly independent in the first sense diminish our personal dignity. After all, I would not last long, and I think most of us would not, without the social context in which I live, since I certainly cannot provide everything needed for my life, let alone a good life, as many people from Aristotle to Alistair McIntyre pointed out. It is interesting in this regard that C.S. Lewis in The Great Divorce sees hell as an ever-increasing distance between the damned. Yet it seems that the entire discourse surrounding the viability standard nevertheless presupposes a legal priority of the first kind of independence. And because it presupposes this sense of independence in law, it also presupposes this sense of independence for the order and structuring of society. Under these conditions, the inherently natural communities of marriage and family will increasingly seem like assaults on freedom and personal dignity. Presumably, Alito has the first sense in mind when he speaks of the mother's and child's interests as essentially outside each other and in competition. On the other hand, his search for a principle intrinsic to the fetus generates a certain ambiguity in this regard. How is extrinsic independence intrinsic to the fetus? Doesn't it run into the same sort of objection as his critique of viability as determined by the state and availability of medical technology. So I think, and indeed hope, that we are left in Alito with a certain ambiguity. By way of conclusion, what is important to see here, I think, is that defining the person in terms of independence is not neutral regarding absolutes or their disposition toward the big questions in the way that Roe and Casey hope. These two senses of independence mark, when presupposed in their purity as founding principles, two completely different understandings, both of the nature of the, to use Casey's language, the attributes of personhood, and the shape and meaning of social relationships and communities. So we can't just define those for ourselves, right? They're given us. They're necessarily given us. It is the difference between seeing human relationships and communities as natural and seeing them as based on an essentially contractual model. The first sense, the extrinsic sense of independence, suggests a contractual model of society, a voluntary idea of society. For this reason, the viability standard depends on a deep and typically unconscious assumption that the human person is best understood as simply a chooser before he or she is anything else. Or I should say, before it is anything else, because he or she has to, increasingly come after, as we're seeing today, this act of choice. Okay.